Welcome back, everyone. Welcome to panel 1, reflecting on the Second World War setup and status quo today. It's a great pleasure to have with me today 2 experts that will provide brief presentation and then interactive chat and discussion on the issue that the panel 1 raises. The panel is dedicated to reflecting on the post-Second World War setup and the status quo today. It aims to look back from a historical perspective at the Second World War accountability efforts post-Second World War and compare these efforts to the situation today, in particular to the situation in Syria in a given time frame. The main question is to reflect on the similarities and differences, to reflect on the fight against impunity framework and the Nuremberg Principles from a very historical perspective. It is my great pleasure to introduce Professor Annette Weinke. Professor Weinke is professor at the History Department of Friedrich Schiller University of Jena in Jena and co-director of the Jena Center of the 20th Century. She has published extensively on the history of war crimes, tribunals, human rights, and international criminal law. And she is currently working on a project that is collecting biography of emigrated human rights lawyers and activists in the 20th century. We also have today with us Professor David Lesch, who is the Ewing-Halsell Distinguished Professor of History and at the Trinity University in San Antonio, Texas. He has published extensively on the situation in Syria, modern history, and correlated conflict. Dr. Lesch has consistently advised high-level officials in the United States, Europe, Middle East, and the United Nations. It is a great pleasure to have both of you here with us today, and thank you on behalf of the Academy for joining us. We will start with a short presentation reflecting on the accountability efforts and your reflections on the accountability framework and the Nuremberg Principles. And it is my great pleasure to start with Professor Weinke. Professor, you have the floor.
Thank you very much. Good afternoon, ladies and gentlemen. First of all, I would like to thank the organizers for the invitation. Thank you for the kind introduction, Jolana. And I would like to say that it's a great honor to talk in front of this very distinguished audience here today. In the last 3 decades, a growing body of literature has informed us about the late 1940s as the first global human rights revolution. In the vein of Thomas Bürgenthal's awareness-raising, now canonical talk of February 1991, the London Charter, the International Military Tribunal, and the immediate consequences arising from these events are interpreted as driving forces behind an expanded and updated international humanitarian law. This kind of a new justice, as it is often dubbed, materialized itself in a range of new criminal concepts, norms, and regulations, and 5 years after the IMT's opening, in the announcement of the Nuremberg Principles by the United Nations International Law Commission. However, as it has been noticed more recently in the discussions of a critical and revisionist human rights historiography, the term human rights revolution also sheds light on 2 central historical aspects that often get glossed over in comprehensive, more norm-oriented accounts on the histories of international criminal law. Firstly, critical historiography has stressed both the foundation of the IMT and the declaration of the Nuremberg Principles as that there were reactions to a fundamental collapse of the international political and legal order as it has been created in 1919 in the context of the Paris Peace Treaty and the establishment of the League of Nations. In contrast to the critique advanced after 1945 by West German defense lawyers and other opponents of the IMT, who misleadingly blamed the Allied powers for enabling Hitler by the creation of a purely formal, legalistic, and punitive world order, this historical observation does not aim at diminishing the enormous efforts and remarkable results of Nuremberg. Rather, it helps us to understand how the revolutionary character of the whole endeavor was closely tied to the phenomenon of historical crisis and pervasive crisis perception, and how this was impact in the long run on Nuremberg's resonance in the international public sphere. In this reading, the characterization of the Nuremberg Principles as an outgrowth of a legal revolution explains the considerable reservations of liberal prosecutors and judges who, for the purpose of legitimacy, had to rely on a couple of standardized narrations and tropes that traditionally conveyed ideas of continuity and linear progress in international law. Secondly, it explains why it was probably not only the Cold War as such, but also the perceived ad hoc character of the Nuremberg Revolution, which caused many contemporaries to plea for its abandonment in the early 1950s. Against this backdrop, even delegates of the United States who initially had supported investigations of Axis criminality sometimes promoted the return to a more traditional state-centered international law as a normalization after times of crisis and turmoil. This overall shift in priorities was to some extent a consequence of the United States' unilateral backpedaling with regard to issues of international human rights protection and individual accountability, a twist usually connotated with the BRICA amendments. Moreover, scholars of third world approaches to international law nowadays assume that both decolonization and decolonization wars further weakened the principles of a new human rights-based international legal order. Although the Stalinist Soviet Union soon launched a broad propaganda campaign that lamented about a Western betrayal of Potsdam and Nuremberg, it was more than obvious that the ongoing project of socialist nation building, how it was conducted in Central Eastern Europe and many third world countries, and ideas of international criminal law were not compatible at all. In June-July 50, the International Law Commission first formulated and later adopted its famous 7 principles. While it was the legal experts' understanding at the time that they had taken another decisive step in fulfilling Jackson's 45 passionate plea for a truly universalized application of international criminal law, to most external onlookers, the initiative constituted more a reminiscence of a distant past than a promise for a better future. With South Korea being invaded by the forces of the North Korean People's Army on June 25, 1950, the high-flying agenda of the 40s human rights revolution was practically off the table before it had been able to reach the routinized, less spectacular terrains of institutionalized norm setting. To the great chagrin of the Polish-American international lawyer Raphael Lemkin, the Truman government refused to ratify the Genocide Convention despite or because of a 250 pages long petition by leaders of the Afro-American civil rights movement. For the relatively small community of liberal-minded international lawyers and legal activists who still adhered to the ideas of a permanent international criminal court and a robust international penal code, more severe and humiliating backlashes would follow. After the triumphant Israeli victory in the Six-Day War of 1967, the Soviet UN ambassador Nikolai Fedorenko blatantly compared Israel with National Socialist Germany. He demanded a second Nuremberg to try the political and military leadership for crimes against peace, war crimes, and crimes against humanity, thereby wooing both the defeated Arab member states and the displaced Palestinians. To the radical fringes of the Western New Left, the Soviet thesis of a conspiracy of aggression launched by American imperialists and Israeli Zionists fully made sense. It formed the background of a vicious logic that labeled the political, military, and ideological support of Arab terrorism as a revival of the Popular Front's anti-fascist battles of the 1930s. But it certainly would be an oversimplification to argue that the Cold War trajectory of the Nuremberg Principles were their mere instrumentalization for the purposes of political propaganda and historical myth-making. Rather, a wave of new research has shown that the importance of Nuremberg has always transcended the narrower realms of state and interstate institutions. Starting in the 1960s, some of Nuremberg's core ideas, especially those of an individual criminal responsibility under international law, criminalization of atrocity, crimes, and mass crimes committed against civilian populations, and an individual accountability of heads of state, continued to inspire the international struggle for human rights and justice in spite of the stalemate at the United Nations. Despite the fact that until the 1990s, the international community undertook no serious measures to build a more universalized system of international criminal law that would deserve its name, some of Nuremberg's legacies and promises were never completely forgotten. At least in the spheres of human rights organizations, churches, a few academic institutions, and legal think tanks, the emancipatory aspects of its heritage were kept alive and fresh. In a critical assessment of the more recent histories of international criminal law, some historians have made the argument that the rediscovery of Nuremberg's legacy in the 1990s came at the price of prioritizing atrocity crimes over crimes of aggression, thereby inverting the original hierarchies of the late 1940s. Because the Northern powers had successfully met their security needs by the means of clean and hygienic direct interventions, as it is claimed, their belief was that they had nothing to fear from the criminalization of atrocity and extreme violence. Post-colonial scholars have associated the establishment of the Rome Statute and the International Criminal Court with the implementation of a dual standard system that aims at a depoliticization of extreme violence while reproducing asymmetrical power relations and structural deficits in the international arena. While these criticisms should not be brushed aside, it needs to be stressed that not all premises and sweeping interpretations withstand closer scrutiny. Neither were the Nuremberg Principles the hegemonic project of neoliberal and cosmopolitan elites of the West, nor was their invocation characterized by sharp dichotomies between aggression and atrocity crimes. So I conclude. When Bergenthal gave his famous keynote speech in 1991, he opened it with an apology. Had the organizers knew about the upcoming war in the Gulf, they would have invited not him, not a human rights lawyer, but an expert on Middle East affairs. On the other hand, Bergenthal added, the military conflict in the Middle East was not at all unrelated to the topic of human rights and international criminal law. I quote, if we did not have a brutal dictator in Iraq who has been violating human rights on a massive scale for many years, we would not have this war. Human rights violations are often either the cause or the effect of the many armed conflicts we hear and read about daily, end of quote. On the occasion of the 70th anniversary of the Nuremberg Principles and in the face of sharp criticism of international criminal law as an alleged instrument of neoliberal power politics and neo-colonialism, it is worth remembering Bergenthal's message that doing justice cannot be separated from peacekeeping and political reform, explicitly addressing Bergenthal's underlying ideas and critically reflecting the grievances of ICL's critics and the formulation of an additional Principle 8 that could be possible could be a possible approach to underline that ICL has never been an ahistorical nor an uncontested project. Thank you very much for your attention.
Thank you very much, Professor Weinke. Now I would like to give floor to David and Professor Lesch. Thank you.
Ilana, thank you very much. And as with my distinguished colleague, I'd like to thank the organizers for holding this and giving me the honor of making my presentation. I'm going to give a little bit of a different approach than Professor Weinke gave, as it's my charge to examine what has happened in Syria since the beginning of the civil war in 2011, that to some respects is still going on. And it's also, of course, a government, Bashar al-Assad, that has been accused of war crimes and crimes against humanity. As many people in Middle East field know, I met with Bashar al-Assad on a regular basis between 2004 and 2010, and much of the rest of the Syrian leadership. And I continued to meet with a number of members of the leadership during the war in Damascus and elsewhere. One time I met with one of the top security people to Bashar al-Assad. He met with or talked with Bashar al-Assad on a daily basis. I met with him in Damascus in 2013, a few times in Beirut between 2014 and 2016. I remember on one occasion, we talked about the beginning of the Civil War. And as many people know, it started with protests in the southern city of Daraa in March 2011, which is near the Jordanian border, when some teenagers who had written anti-regime graffiti on one of the walls there were taken by the Mukhabarat, or Syrian security, and tortured. And their families and friends and so forth protested in Daraa. Syrian security, as it normally does, it tried to put down the protests, and there was violence, and there were some security people killed on the Syrian government side. And I remember when discussing this security person, one of the top people in Syria, again, at the time, he said the following quote, which really stuck with me. He said, "We had to respond with force. We had to respond with force." In other words, it was a reflexive, expected response. And he expected me to understand that and to almost give him sanction for responding the way he did. And in his opinion, from that point on, there could be really no reconciliation along the terms that many of us wanted to see, which is the Syrian government said it tried until that point. And the thing is, there was no institutional mechanisms to deal with this type of situation. In the United States, of course, we had our January 6th riots early this year, where there was violence on both sides in the US Capitol. But the US government did not respond with brute force, but has hunted down those perpetrators through the justice system. And so without institutional control, preventing any perception of weakness becomes paramount from an authoritarian perspective, as you believe that you are seen and judged in a more direct light. Even when the regime or government made concessions in April 2011 in response to the initial protests, it said that it was only implementing that which it had already decided upon. That is, it could not be seen to be directly caving in to the protesters. So what I'm going to talk about in my brief presentation today is what I think I can bring value added to the table, is what the Syrian government, what Assad thought and perhaps still thinks, in order to try to better understand their conceptual paradigm, how they viewed the nature of threat. It doesn't excuse any of their actions, of course, but I think it's important to at least understand their perspectives in order to better find ways to intercede before mass atrocities are committed. Now, Assad spoke on March 30th, 2011 in a highly anticipated speech, his first speech to the nation in reaction to the protests, and he branded terrorists, conspirators, and armed gangs as primary reasons for the unrest. And this is still the government narrative. Most of us, outside of Syria, scoffed at such blatant misdirection from the real socioeconomic and political problems that brought the so-called Arab Spring to Syria. But many Syrians, even Assad himself, really believe this perception. Their perception of the nature of threat is vastly different from what we see outside of Syria. It's a conceptual gap. blame it on Syrian paranoia bred by real and imagined imperialist conspiracies of the past, Arab-Israeli conflict, and/or regime brainwashing to consecrate the necessity for the security state, but is in large measure a function of living in a dangerous neighborhood where real threats are indeed often just around the corner. I'm also sure that if I had met with Assad at any time during the conflict itself, during the civil war itself, he would point out to me that he has made extensive concessions and enacted dramatic reform. He would complain that he wasn't receiving any recognition or credit for this, and as such, he would conclude, as he has done in the past, that the United States and the West have it out for him. No matter what he does, it would not be enough. And I think he would sincerely believe this. In fact, from the beginning, the regime saw the uprising as an attack on Syria, an ongoing conspiracy by its enemies to weaken it. The Arab Spring just provided such an opportunity. But Assad is a product of an authoritarian system, one that is a paradigm of stagnation and control. I got to know, as I said earlier, Bashar al-Assad very well. He seemed to be different than the typical Middle East dictator or the Saddam Hussein, Iraqi dictator that Professor Winke spoke about, which led many people, including me, to hope he might incrementally change the system in his first 10 years in power. In my view, Assad lost his way. As we all know, the arrogance of authoritarianism will do that because power is an aphrodisiac. And either he convinced himself or was convinced by the sycophants around him that the well-being, his well-being was synonymous with the well-being of the country. Now, what he was doing in terms of violently putting down protests and not meeting demands of change were both necessary and correct. In a way, I saw a progression as I met with him over the years that he became much more comfortable with power, which is not necessarily a bad thing, but in an authoritarian system, it means you're becoming much more comfortable with being an authoritarian leader. And he assimilated into the system rather than changing the system. Roger Owen, a Middle East scholar, wrote a book a few years back called The Rise and Fall of Arab Presidents for Life. And he talked about the alternate realities that are typically constructed around a leader. You hear the praise in reverence on a daily basis, you begin to believe it. And this is human nature. I believe Assad developed a strong feeling of triumphalism in his first 10 years of power, particularly after 2005, when he survived the recriminations and accusations following the assassination of former Lebanese Prime Minister Rafiq Hariri in Lebanon, and Syria was blamed at the time. He survived. He felt he was righteous. His destiny was to rule. And I think this played a crucial part, in my opinion, in his response to the uprising in 2011. He believes what he did and is doing is not only surviving, but saving the country and saving a way of life. The Civil War was just another significant challenge from which he shall emerge victorious. Whether it takes a decade or more, they see it very much as a long-term process. You hang around long enough to the point where changing circumstances improve his lot, where the West's narrative changes and starts to see him maybe not as an asset, but less of a threat. And this is what we've seen happening over the last couple of years, and especially even the last few months. In another sense, the Syrian government's crackdown was a push-button, convulsive response to domestic threat. It is business as usual. It's not as though Assad does not control the security forces. It is that this has been the way the Assads have worked in Syria for decades. The Syrian security forces have tremendous leeway. I have a number of stories of personally being approached, I'll just say euphemistically, by the Syrian security forces. So Bashar simply, in my opinion, went along with business as usual instead of understanding the new circumstances created by the Arab Spring. I think he was absolutely shocked by the widespread nature of the protests. He thought he was popular beyond condemnation because he was different than the Hosni Mubaraks of the world or Muammar Gaddafi's of the world. He was younger, in tune with the Arab youth, against what they called the US-Israeli project at the time. The protests had to be the result of pernicious forces from outside of Syria, because surely this could not be an indigenous uprising. One colleague of mine, Peter Harling, said at the time that the regime, almost took the protests as an assault, as an insult, that the population was ungrateful. And he wrote at the time, quote, "For the regime, its supporters and its allies, Syria's is an immature, if not disease-ridden society. They posit with evidence both real and invented and generally blown out of proportion that Syrian society shows sectarian, fundamentalist, violent, and seditious proclivities that can be contained only by a ruthless power structure," unquote. So in other words, very much easier to demonize the opposition when it arose and to take violent action against them. I think in the end, Assad retrenched into a typically Syrian authoritarian mode of survival, an Alawite fortress to protect the sect's chokehold on power. Many of us, as I said earlier, hoped Assad would change the system. It seems what happened is that the system changed him. And the rest of the story is fairly well known. Russia intervened on behalf of Assad and other countries, of course, Iran, allied with the Assad regime. And Russia intervened militarily in September 2015, essentially becoming the Syrian Air Force, and turned the tide of the war, which was not going Assad's way, the Syrian government's way at the time, after ebbing and flowing for some years. And since that time, the Syrian government has incrementally extended its control with Russian help, with Iranian help, with Hezbollah help, over most of the major cities in Syria, save for the northwest, Idlib province, which is under control of the remnants of the Syrian opposition supported by Turkey, and the Kurdish-dominated Syrian Democratic Forces in the northeast, supported by the United States. And I think the problem right now of restorative justice, transitional justice occurring in this situation against the Syrian government and others in Syria as well, you know, those in the opposition with Al-Qaeda affiliated groups, ISIS, etc., that have carried out atrocities, is that the Syrian government right now is being rehabilitated for geostrategic and economic reasons, and with the silent consent, I think, of some world powers, including the United States. Syria's centrality in the Middle East makes it difficult to ignore, and therefore it's going to be difficult, I think, to bring any perpetrators of wars against war crimes and crimes against humanity to justice in this type of environment. As Professor Wenke clearly noted, these things oftentimes become politicized, and the conspiracy theories abound with regard to Syria from the Syrian perspective, from the Russian perspective, which protects Syria in the UN. And of course, Syria is not a signatory to the 1998 Rome Treaty establishing the ICC. So, and of course, Russia will block any sort of UN referrals to the ICC with regard to bringing those accused people to justice. So it's going to be very, very difficult. And I think this is one of these long-term projects, long-term situations where, you know, as again, Professor Wenke pointed out, there was a quote where justice cannot be separated from political reform or political settlement. And in this case, in the short term, it may have to be. So thank you very much for your time.
Much for these insights and these views, both Professor Weinke and to you. I would briefly like to raise a point that came to my mind when I listened to you, David, and that is a statement that the late Hans-Peter Kaul, the first German judge at the ICC, has made. He had this gift of making complex things more digestible. And he said, and I think he is very true, or has been very true, there is no war without war crimes. And that means that to some extent, it doesn't matter whether the Syrian regime was entitled to defend itself. It's the question how they defend that. And even in the most just war, everyone must face the challenge that war crimes and crimes against humanity have been committed. We saw this in so many other conflicts, and that, I think, is what the Nuremberg Principles ultimately request. It doesn't matter, let alone the crime of aggression. I admit that, frankly, but it doesn't matter whether you fought a just war or an unjust war. If there are war crimes and crimes against humanity committed, even those who fight a just war will be held accountable for these crimes. And I think it is actually a task for the entire community, and the Security Council will have to answer that question at one stage. Why did you not do what the Nuremberg Principles demand, independently from the question who was right or who was wrong? And I think this is sometimes a bit of the difficulty when we look in hindsight into conflicts, where it's much easier, of course, than in an ongoing conflict to identify who plays what role. and who has been forced in what dimension to react. But one thing is clear: even those who defend themselves lawfully and rightly need to face the accusation that there might have been a war crime or a crime against humanity committed, and that is what the Nuremberg Principles actually demand.
Mm-hmm. No, I agree. There's nothing exists such as a clean war,
yeah,
and which is why a number of countries, including my own, are not members of the ICC. If you look at those who are not members of the ICC, they seem to be countries who are often at war. And you know, again, unfortunately, you know, this is a case, as in most of these cases. I mean, the perpetrators are not going to give themselves up to the international community for you know, adjudication. You know, from their perspective, the halls of international justice are warped and biased and controlled by countries that are already to seek to undermine them. So it's self-serving, but it's also, and one of the points I was trying to make is this is in many ways the way they think, the way their reality has been constructed, the way they've been taught. And again, it's not, you know, it has been bred by conspiracy and imperialism over the years and people being out to get them, but it's also very self-serving. And it's so easy, as we've seen since World War II, how easily it goes from you know, how easily it can be to rationalize atrocities, to rationalize death, and to rationalize violence in the way that we've seen over and over again throughout history.
Thank you for these wonderful presentations and reflection points. The entire point of this panel was to really dissect the challenges and the complexities that arise from many angles that you've raised, and it's the ones that I've just quickly noted out is really the normative frameworks and the complexities within the normative framework, the complexities of the wider context and the context itself when it comes to addressing international criminal justice objectives and agenda, which we will be also discussing later today. So unrolling some of these challenges from various perspectives. So my question to both of you would be just to briefly summarize, because we have very limited time. So we have 10, 15 minutes maximum to discuss this, but really highlighted the differences and the similarities that you see, and looking at the practical suggestions towards addressing them as in line with the forum objective, really trying to see whether there is any solution or whether there is any practical recommendations that you would have, and really maybe summarizing the points that you have mentioned until now. And I would start with Professor Weinke.
Yeah, this is of course very, very difficult for me as a historian to give recommendations. I mean, first of all, so I was trying to make a point that, yeah, we have to open up the understanding of the Nuremberg histories. We have to acknowledge that this has been a very twisted and complicated, a very messy history since the late 1940s. I think we have to acknowledge that in a way, so that both the 1940s and the 1990s were in a sense exceptional historical moments, and because of this global situation in the late 1940s and in the early 1990s, it became possible to form a broad coalition behind the idea of Nuremberg and the Nuremberg Principles. But nevertheless, I mean, it's clear that there has been strong opposition right from the beginning, and we have to find answers why there are still these enormous legitimacy problems. I mean, there are legitimacy problems, and some of these problems result from discussions during the Cold War. So So the way that how the United States and Russia are dealing with international criminal law today has something to do with their previous or current position as superpowers. And yeah, in a way, there has been always a very broad civil movement in favor of international criminal law, especially in the United States. But nevertheless, it has not become so popular that we can expect that US will be joining this very soon. And I think this is still the biggest problem, that the US is absent from this project. And yeah, this is what I would like to say.
Thank you. So then we have to open up to understand the Nuremberg Principles much more, and also understand the legitimacy behind applying the Nuremberg Principles, if I understood that correctly. David, would you like to take the floor?
As Klaus pointed out, there's a difference between looking back historically and something that is ongoing, such as the Syrian Civil War, and the story of the Syrian Civil War has yet to be finished. You know, a number of people are brought to justice for crimes against humanity and atrocities and so forth when, you know, after they fall from power or removed from power. That has not been the case. Of course, Bashar al-Assad has just won another 7-year term, and there's really no, you know, no end in sight in the near term in terms of him remaining in power. But I've really struggled with this in real time because, fortunately or unfortunately, I'm involved in some of these processes and initiatives regarding Syria, and you know, it's this dichotomy between, you know, do we help relieve or remove or waive the sanctions on the Syrian government in order to help the Syrian people? Do we accept the fait accompli? It seems that he's going to remain in power, that, you know, it's that he has control over most of the country, and that most or a number of countries in the Arab world are you know, have reopened their embassies in Syria, are clamoring for Syria to be returned to the Arab League. Jordan just opened up its border with Syria, and the Jordanian monarch, King Abdullah, had a phone call with Bashar al-Assad recently, and Jordan would not have done that without a green light from the United States. Bahrain would not have reestablished its embassy, reopened its embassy in Damascus without a go-ahead from Saudi Arabia. So, you know, these things are slowly happening, again, mostly because of the centrality of Syria, and because, you know, many countries don't want to see Lebanon fall. And so there's been, you know, this deal to share electricity and gas from Egypt and Jordan through Syria to Lebanon, and therefore certain sanctions are being waived in that regard. And so where is that line drawn between keeping up the pressure and hopefully bringing about some sort of political settlement? And everyone's hoping for, you know, for a long time during the Civil War that would end up removing Bashar al-Assad, which of course is why Bashar al-Assad and the Syrian government did not really participate in all of these political processes sponsored by the United Nations, because they knew it was just a backdoor to removing him from power. So we're really at this crossroads right now, and I struggle with it, you know, and morally and in a practical level. That we've seen throughout history, and we're seeing it now in Syria.
Thank you. So what I just noted down for everyone, so really looking at the different context and the differences between ongoing situations, reflecting on it, and really looking at the objectives. And I think that this is going to be the continuing thread of, at least with the beginning of panel 3, in terms of objectives, the various tensions, the various the transitions between criminal accountability and then wider fight against impunity and the transitional justice context. So I'm sure we'll continue this discussion over the at least next 2 days. But I would like to ask, yes, from your seat and your perspective as historians, what is your aspiration for the Nuremberg Forum? Where do you see it could add value? Any posing questions that you have to add, and any reflections on, yes, the start of the fight against impunity living up to the Nuremberg Principle posed question? And I give the floor to Professor Weinke.
Basically, I would like to take the opportunity to address David with a question. So basically, I mean, how is your assessment of these current investigations against Syrian perpetrators who are abroad? I mean, is this in a way helping the whole endeavor of human rights and international criminal law, or do you see more the risk that that the victims will become a target again, or that their families will become targeted? So where do you see the pros and cons of these current investigations?
Yeah, I mean, there are a number of them, of course, against those who are accused of torture and so forth, and a lot of information being collected that could be useful at some point down the line. I think it's creating this sort of collective paradigm that at some point, may be useful against Syria. I guess there's also the idea of perhaps the refugees situation, and there have been some analogous to what happened in Myanmar and Bangladesh, and the problem there, of course, was that it's difficulty proving that refugees have been forcibly removed from Syria, as has been the case in some other instances. Yes, in most of the case in Syria, they're fleeing atrocities, they're fleeing just the depredations of war and poverty and so forth, going to other countries. So it's difficult to prove any sort of forcible removal. So these much more about this, Anna, than I do, but it just seems that these sort of bits and pieces that are collected over the course of time could then create this body of data and rulings that can, in addition to all of the other investigations that have occurred against the Syrian government in many different venues, may be useful down the road.
Yeah, especially because there's a kind of a smear campaign against human rights organizations who are engaged in Syria right now.
Yeah, exactly.
So can I give just the quickly floor to Dr. Weinke for really quick reflections on the discussion and last minute reflections, and then turn to Professor Lesch, because we need to quite finish on time with the busy schedule that we have an immediate panel 2 following this panel. And yes, I would like to thank you both for participating, raising all these challenges that I think are going to really set the tone for the next discussions when we're turning to much more really addressing the system and systems and various objectives and how to reflect on the Nuremberg Principles and fight against impunity. So Professor Weinke, the floor is yours.
Yeah, basically, I think I have already summed up my general thoughts. I mean, I think that in a way, the community of international scholars has to, in a way, address the historical challenges as well. So this was more or less the essence of my talk here, that you have to develop a critical consciousness of the trajectories of international criminal law since the late 1940s in order to understand the present problems. So this is my plea as a historian.
Thank you, Professor Lesch.
Yes, I think one of the important aspects of the Nuremberg Principles in its application to Syria is that, I've been long saying that there is the physical reconstruction of Syria, which is very much politicized. There's an economic aspect to that, of course, but also the emotional reconstruction of Syria. Just as in any conflict scenario, that is sometimes more important and create more long-term sustainability and stability for decades to come. And, we saw these so-called dignity panels in South Africa and Northern Ireland that brought, opposing groups together to air out their grievances and talk about things. And it's difficult to do that without some sense of justice from one side to the other. And I'm not saying one is, the government side. If you had a dignity panel or any of these reconciliation panels, the government side, they would lay out and I've been on these discussions, they'd lay out as many atrocities as the other side would do against the government. And so, justice is very, very important element of that. And justice, the concept of social justice is exceedingly important to Syrians in general. I don't know if it's any more than anywhere else, but it's exceedingly important. So I think that whole concept that the country cannot emotionally and socially and culturally recover from this without it.
Thank you. And thank you very much for your panel 1 presentation. We are grateful. I hope you stay with us for the panel 2 and the continuing discussion, because I think it would be very interactive to see your questions and follow-ups in a public chat and trying to see how the various perspectives combine and mix together with our hope to advance the discussion itself. So thank you from our end. And I would like to start introducing panel 2.